class, my name is Gabrielle Colhane, and the case that I will be presenting today is United States v. Anderson, cited in page 160. Please proceed to the next slide. Between the years 2005 and 2009, both Andrea and Norman Anderson ran a Ponzi scheme. During this time, they were able to defraud 11 victims of their money. According to evidence, the Andersons would tell their potential victims that they were successful investors who wanted to help others attain the same success in investing that they had achieved themselves. The Andersons had developed a fake persona by the name of Lenore Lawrence. This persona was the alleged sister of Andrea Anderson, who they had claimed worked at Goldman Sachs. The Andersons told their victims that they had held a large sum of money in an investment account at Goldman's. They then told their victims that Lenore would be the one purchasing the stocks in which they were to provide them money with. The victims then sent their money to the Andersons' personal bank accounts through wire transfers, cashier's checks, personal checks, and cash. Some cases, they were told to have their money invested in Rosetta Stone, and others in public stock of Visa. The Andersons would then send fraudulent emails claiming to the victims payments had been made, and sometimes would even tell the victims to send more money. Please proceed to the next slide. Eventually, the victims would catch on in a sense, and would want to sell off their stocks to get their money back. The Andersons would then send false emails to their victims, claiming that they were from Lenore Lawrence. None of the victims had ever spoken to Lenore over the phone. Andrea Anderson sometimes would respond to the victims by sending them forged emails, supposedly from Goldman employees. Andrea sometimes would meet up with Goldman employees, acting as if she wanted to open an account. When the Goldman employees would then follow up with her and send her other emails, she would then modify and change those emails and forward them to her own victim. During the investigation, Goldman's evidence showed that there had been no one employed by the name of Lenore Lawrence, and that the Andersons did not own an investment account there either. Evidence did, however, prove that the Andersons did own a few investment accounts, however, at TD, and had invested some of their victims' money. However, the Andersons had mostly made losses and little to no returns. 11 victims lost a total of $915,687.63 through investing with the Andersons. Please proceed to the next slide. Some of the issues at hand were the fact that, should Andrea and Norman Anderson be held accountable for 11 victims, or their claim of 9 victims? Is there sufficient evidence showing that Andrea and Norman Anderson conspired together? Should the court accept or deny the defendant's motion to dismiss the attempted conspiracy charge? Is there sufficient evidence showing that the two had made false claims about their connection to an investment firm? In determining the punishment for the acts committed, please proceed to the next slide. Andrea and Norman were both charged and convicted of one account of conspiracy to commit wire fraud and 11 accounts of wire fraud by a federal jury. The Andersons were also sentenced to 57 months of imprisonment by a district judge. The evidence presented to the court showed to be sufficient to convict both Andrea and Norman of conspiracy to commit wire fraud. Evidence proving that the two worked together and had made misrepresentations about an investment to their victims. The evidence proved to also be sufficient to convict the two defendants of wire fraud, showing that the two had specific intent to defraud, lying about investments to their victims to get their victims to invest their money with them. Both defendants filed a motion to dismiss the charge. The district court denied their motion, finding that the state was clearly a freestanding criminal charge, and that the defendants were rightfully charged with such. Please proceed to the next slide. Andrea and Norman both objected to the pre-sentence investigation report's results. The results showed that the total loss from the Andersons' victims accumulated a cost of $1,009,712.72. With the loss being above $1 million, the Andersons' offenses would then take them from a 14-level increase to a 16-level increase. The Andersons argued. Please proceed to the next slide. Additionally, the Andersons claimed that the number of victims had been miscalculated in the report. 3 of the individual victims had created a joint investment account with one another through the Andersons. Therefore, the Andersons used this to their advantage. They claimed that this group of 3 should therefore only count as one victim, taking them from a total of 11 victims to only 9. By taking themselves from 11 to 9 victims, they then go underneath 10. By being under 10, they would avoid the 2-level increase that they would be. Please proceed to the next slide. The PSR did take into account their objections. They recalculated the loss from over $1 million to around $900,000, as stated previously. However, the PSR did not change their stance on the number of victims that were affected by the Anderson. Please proceed to the next slide. In Copeland versus United States, Copeland was caught and charged for possession of marijuana and money laundering. He argued that some of his recent charges were unconstitutional and filed a motion to appeal. He then stated that his drug conspiracy statute that he was charged with has no override act, quoted in the case in United States versus Anderson, stating that the Supreme Court has held that there is no constitutional problem with the lack of an override act requirement and has upheld. United States versus Bean uses Anderson's case to justify conspiracy to commit fraud. When Bean filed his motion to dismiss his indictments, the court found to disagree with his claims of the court failing to allege the federal offense. The courts have found to impose liability for conspiracy to commit wire fraud, and that is a freestanding criminal charge and not a penalty provision. United States versus Bean uses Anderson's case to justify conspiracy to commit fraud. When Bean filed his motion to dismiss his indictments, the court found to disagree with his claims of the court failing to allege the federal offense. The courts have found to impose liability for conspiracy to commit wire fraud, and that is a freestanding criminal charge and not a penalty. In United States versus Ingles, in which the father of Ronald Ingles, Donald, had his longtime friend, Willie Hilson, set fire to his son's camp houses. Willie had called him late one night and told him that it was over with, referring to the burning down of the two homes. The next day, Ronald filed claims to the insurance company regarding the burning down of his two camp houses. He was to be paid by the insurance company, State Farm, but he was convicted of being involved in the arson. Ronald, Donald, and Willie were charged with wire fraud for the phone conversations, 4 counts of mail fraud, and conspiracy to commit mail and wire. Please proceed to the next slide. Chapter 5 in our business law textbook deals with criminal and law procedures. Wire fraud and investment scam is a criminal offense in the United States. Also, it is a white-collar crime. This case is important to not only the chapter, as it reflects the chapter's teachings, but to case law as well. Similar cases have and will proceed to follow the same rulings of this case. The United States versus Anderson will serve as a platform and allow following cases to have a platform in which to stand and sit.